According to Chief Justice of Nigeria, the Apex Court considered 2,280 matters between September 2004 and July 2005. This comprises of 1,720 motions and 560 appeals. These motions include 1,025 civil cases, 488 criminal cases, and 27 Sharia-related matters. While the appeal consists of 352 civil cases, 180 criminal cases, 6 political, 15 Sharia, and several originating summons. The Chief Justice of Nigeria noted that this was a significant improvement from 1,124 handled cases and 247 judgments delivered during the 2003 and 2004 legal year. You can see the huge figure. And these are the latest publicly reported figure for case backlog and pending cases in the Nigerian judiciary. As of the first quarter of 2024, the Chief Justice of Nigeria, Kudirat Kekereekun, stated that the Superior Court recorded, excluding the Supreme Court, had 243,253 pending cases. This comprises of 199,747 civil cases and 43,506 criminal cases. For the Federal High Court of Nigeria, it was disclosed in December 2004 that there were 155,969 pending cases across its divisions: civil, criminal, fundamental human rights, etc. And there are some general commentaries from the May 2005 reported that Nigeria faces over 150,000 case backlog nationwide in the court, and this is pointing to serious congestion. Early 2004, there were about 243,000 pending cases just in the Superior Court, 156,000 pending cases in the Federal High Court as at the end of 2004. So, if you can imagine these figures, and maybe remember this figure, I got it from the Vanguard newspaper, Business Day in Nigeria. You can check them online. Some of the newspapers that reported about Nigeria legal year cases and pending cases on the Nigeria legal year. So what is the effectiveness of mediation in reducing court case backlog? Mediation has increasingly been recognized as an effective dispute resolution method for addressing the problem of court congestion, prolonged litigation. Its effectiveness in reducing court case backlog can be explained through several key points. Faster resolution of disputes. Faster resolution. Mediation typically takes days, weeks, compared to several months and years often required for court processes. By resolving disputes more quickly, mediation helps to free up judicial time for other complex cases. The effectiveness of mediation in reducing court case backlog encourages early settlement. Court that refer cases to mediation at early stage often experience a significant drop in caseload. Early settlement prevent unnecessary trial preparations, adjournment, appeals, which are major causes of backlog in the court system. Mediation is cost effective since it reduces financial burdens. Parties are more willing to settle rather than prolong the cases in the court, reducing the number of artifacts in the court. Mediation promotes voluntary compliance. Agreements reached through mediation are mutually acceptable, leading to higher rate of compliance. And this limits post-judgment dispute enforcement cases, further reducing the caseload for the court. Mediation is very flexible. Mediation allows for creativity, interest-based solution outside of the strict legal frameworks. The flexibility means more disputes can be more resolved without reverting to the former judicial processes, and this will relieve judges and the court staff from too many pending cases. Diverting cases, especially for the civil families small claim matter to mediation, allow judges to focus more on serious precedent setting cases. As a result of that, judicial efficiency improve and backlog cases shrink because of mediation. Countries like Nigeria, Kenya, Ghana, and other African nations have introduced also court connected mediation centers like the multi-door court houses, and you can also find here in Lagos. In the US, the UK, court annexed mediation program have also reported a substantial reduction in dependent cases. So it's very important that mediation is faster and I know most professionals in the legal system they kind of resist they prefer litigation. They kind of resist mediation because it's one of the challenges. And people are being there's low public awareness or trust in the mediation process, and people are also thinking are there limited enforcement mechanisms, lack of trained mediators, and these are challenges. But I think because the public are a little bit underinformed about the mediation process, and that's why they think everything is litigation. Mediation is a powerful tool for reducing court case backlog by resolving cases dispute quickly and amicably. And when it's been integrated into the judicial system with strong institutional support and public participation, it significantly enhances access to justice and eases court congestions. According to the Chief Justice of Nigeria, the Apex Court considered 2,280 matters between September. I've mentioned that figure before. I've mentioned them. And you can imagine Nigeria comprises of 36 states. So if you go about maybe going to different court, the High Court, the State High Court, the Federal High Court, the Customary Court, and go around all the courts, and Nigeria is populated, and Maybe you get all the figures from all the courts and see number of pending cases, adjournment, cases for trials, a huge backlog cases. Sometimes the judges they're on holiday, they're on vacations, or the court is on vacation also. This prolonged cases in the court. And why there is mediation and all the dispute resolution method that can ease the condition of the court system. So it's very important we educate the public about mediation so people can switch, people can have amicable resolution faster. So it's very important the court system collaborate with mediators to ease the condition of the court. Mediation is not just an alternative, it's a method of dispute resolution mechanism.